Hearing none, the minutes are approved. The House Judiciary Committee will come to order. Will the clerk please call the roll?
Chair Thomas.
Here.
Vice Chair Swearingen.
Here.
Ranking Member Isaacson.
Here.
Representative Callender.
Here.
Representative Matthews.
Here.
Representative Mohammed.
Here.
Representative Odioso.
Here.
Representative Olslager. Representative Plummer. Representative Stewart. Representative Sonnenberg. Representative Timms. Representative Williams.
We have a quorum present. We'll proceed as a full committee. The minutes from the previous meeting are on your iPads. Please review the minutes. Are there any objections to the minutes? Hearing none, the minutes are approved. Friendly reminder, in order to record audio or video of this committee, you must submit an AV request form to the Office of the Chair. All supporting documents and testimony today can be found on your iPads. If the public wishes to be informed about upcoming hearings, please visit the Judiciary Committee website at ohiohouse.gov and sign up to be on the distribution list. I'd now like to call up House Bill 168 for its fifth hearing, and I call on Vice Chair Swearingen for a motion.
Thank you, Chair Thomas. I move to favorably report House Bill 168 out of committee and recommend its passage.
Will the clerk please call the roll?
Chairman Thomas.
Yes.
Vice Chair Swearingen.
Yes.
Ranking Member Isaacson.
Yes.
Representative Callender. Representative Matthews.
Yes.
Representative Mohammed.
Yes.
Representative Odioso.
Yes.
Representative Olslager.
Yes.
Representative Plummer.
Yes.
Representative Sonnenberg.
Yes.
Representative Williams.
With sufficient votes, the bill is favorably reported. The roll will stay open until noon today. This concludes the fifth and final hearing for House Bill 168. We request that LSC harmonize this as a substitute bill with the substitute bill. The chair will now call up House Bill 296 for its first hearing. Representative Melanie Miller is here to provide sponsor testimony. Welcome.
Thank you, Chair. Chair Thomas, Vice Chair Swearingen, Ranking Member Isaacson, and members of the House Judiciary Committee, thank you for the opportunity to provide sponsor testimony on House Bill 296. This legislation establishes a 180-day or about a 6-month grace period for outstanding court-assessed fines or fees owed by incarcerated Ohioans when they immediately exit prison. Imagine for a moment being let out of prison after months or years of incarceration. You've paid your debt to society and you're ready for a fresh start. You want to rebuild your life, make better choices, get a job, find a home, and reacclimate into society. However, you're immediately faced with mounting fines and fees that have accumulated during your time. And because you haven't been able to get a job yet, the amount continues to rise. Imagine the hopelessness and feeling of helplessness this situation can create. When someone is released from incarceration, we know that there are many obstacles that can stand in the way of success. This legislation intends to help individuals overcome a huge barrier that has the potential to change the trajectory of their path forward. In the early period after prison, the risks of recidivism, suicide, drug relapse, homelessness, and unemployment for men and women are particularly high. Ohio communities are safer, stronger, and more prosperous when returning citizens can quickly find work, secure housing, get access to reliable transportation, and begin to establish a sense of normalcy and purpose in their lives. I want to be clear about one thing in this bill. It does not forgive debt. It does not change the amount owed, and this does not apply to restitution. Instead, it simply presses the pause button for 6 months to give returning citizens a brief window of relief, or what I like to say, a grace period, so that they can concentrate on what really matters, finding that job, securing that place to live, and reconnecting with a family and their community. No payments would be required for fines, fees, financial sanctions, or court costs related to criminal proceedings during this pause. The states of Alabama, Oklahoma, and Tennessee already offer a 180-day grace period for fines and fees after incarceration. And Ohio has an opportunity to also lead on this initiative and implement a common sense policy that supports both reentry and public safety. Let's give Ohioans who have served their time a little grace and a real chance to succeed while supporting our communities at the same time. Thank you, Chair Thomas, Vice Chair Swearingen, Ranking Member Isaacson, and members of the House Judiciary Committee for the opportunity to provide sponsor testimony for House Bill 296. And I'd be happy to answer any questions that you may have at this time.
Thank you, Representative Miller. Are there any questions for the witness? Representative Mohammed.
Thank you very much, Mr. Chairman. Thank you, Representative, for your testimony. Great piece of legislation. I just wanted to follow up and ask, I know this applies to fees and financial sanctions. Does it apply to any sort of court-ordered programs? Because I know some of those programs can be costly. Community service, would it apply to any drug treatment programs? Because those typically would require transportation and they have some additional costs that come along with that. Would those be told as well? Or if not, would you consider that possibly? Thank you.
Through the chair to the representative, I will get back to you on that. I don't want to speak offhand one way, but I want to verify that for you and I can get back to you. But I appreciate that question, bringing that to my attention. Thank you.
Any other questions for the witness? Seeing none, thank you for bringing this bill forward. Appreciate
Thank you so
much. This concludes the first hearing for House Bill 296. I'd now like to call up House Bill 323 for its first hearing. Here to provide sponsor testimony are Representative Lorenz. Is Representative Lorenz?
Yes, sir.
Thank you, Chairman Thomas, Vice Chair Swearingen, Ranking Member Isaacson, and members of the committee. Thank you for the opportunity to provide sponsor testimony on House Bill 323. This bill addresses a serious and heartbreaking issue, the sexual assault of minors in the workplace. As lawmakers, one of our most fundamental responsibilities is to protect our most vulnerable, and that includes the young people who are just beginning to enter our workforce. House Bill 323 would require employers in Ohio to report suspected sexual assault involving minor employees to the appropriate authorities. Specifically, it amends sections of the revised code to ensure that when an employer has a reasonable cause to suspect that a minor in their employment has been sexually assaulted, they are legally obligated to report it, just as teachers, doctors, and other mandated reporters already are under Ohio law. The inspiration for this bill came after hearing real stories where young workers were taken advantage of and their trauma was made worse by silence or inaction. No child should have the fear going to work, and no employer should ever look the other way when faced with signs of abuse. Let me be clear. This bill is not about adding red tape or making life harder for responsible business owners. It's about ensuring that adults in position of authority, including those in the workplace, take action when something is clearly wrong. Most employers would instinctively do the right thing. House Bill 323 ensures the law expects them to. By adding this safeguard, we are creating a culture of accountability, one that says protecting our kids is not optional. I believe this is a common sense bipartisan measure, and I look forward to working with my colleagues on both sides of the aisle to see it through. Thanks for your time, and I'm happy to answer any questions.
Thank you for your testimony. Are there any questions for the witness? Representative Williams?
Thank you, Chairman. Thank you, Representative, for introducing this legislation. I think it's important that anytime that we know that a minor has been sexually assaulted or we even have reason to believe that they're a victim of sexual assault, it should be reported. I don't want to put the onus just on employers. Would you be open to expanding this to anyone? It's a simple fix in the statute that would say anyone that has knowledge or reasonable belief that a child has been sexually assaulted, abused, neglected will be required to be a mandatory reporter. Other states do that as well.
Absolutely. And, Representative Williams, we've talked a little bit about this offline, and I think that's important, and I'd be happy to have future dialogue with you on that. Thank you.
Any other questions from the committee? Seeing none, thank you for your testimony.
Thank you. Appreciate it.
This concludes the first hearing for House Bill 323. I'd now like to call up House Bill 195 for its second hearing. One order. Yeah. Here to provide proponent testimony is Jeff Farrell. I apologize if I didn't get your name right. Please welcome.
So, Mr. Chairman, the first guy to pronounce my name Ariel was my father's sergeant on his first day in the Army.
Okay.
He'd never heard that noise before.
Okay.
And he learned right away and pronounced his name the sergeant's way the rest of his life.
Got it.
Rhymes with burial.
Okay. Thank you.
So Chairman Thomas, Vice Chairman Swearingen, and Ranking Member Isaacson, and members of the committee, thank you for the opportunity to submit proponent testimony on House Bill 195 on behalf of the Ohio State Bar Association. My name is Jeff Farrell, and I'm a retired member of the Law School faculty at Capitol, where I taught contracts, bankruptcy, and uniform commercial code topics for many, many years. I'm not only here today as a representative of the Ohio Bar, I'm also here as a member of the Ohio Council on Uniform State Laws, which we believe is the single smallest state agency. We fly so far under the radar that most of you don't even know that we're a state agency. As a member of the Ohio Council on Uniform State Laws, I'm also a member of Ohio's delegation to the National Conference of Commissioners on Uniform State Laws. And those of you who are lawyers remember studying the Uniform Commercial Code and the Uniform Partnership Act and the Uniform Limited Partnership Act and a variety of other statutes, all designated as originally drafted as uniform. So since I'm here on behalf of the Uniform Law Commission, it's impossible this week for me to fail to mention former state Minnesota Speaker Melissa Hortman. Melissa was a uniform law commissioner from Minnesota, and I've been acquainted with her for 13 or 14 years. And it was just a very sad weekend and very sad for all 300 members of the Uniform Law Commission. But I'm here today to testify about House Bill 195. House Bill 195 contains a brand new article of the Uniform Commercial Code. The UCC is the Uniform Law Commission's single most important piece of legislation. It's a bulwark of state law governing commercial transactions in the United States. House Bill 195 will update the UCC, like many other bills have updated the UCC in the last 63 years since it was promulgated, by doing three main things. First, it provides in what will be new revised code chapter 1314, what's essentially a negotiable instruments law to ensure the safe and effective transfer of digital assets like cryptocurrency, like non-fungible tokens, like electronic accounts receivable and electronic warehouse receipts and electronic bills of lading. Secondly, it will make amendments to existing Chapter 1309 of the Ohio Revised Code dealing with security interests to ensure that creditors who rely on electronic digital assets as collateral for their loans are protected when they disperse funds. Third, it makes a wide variety of additional very small amendments throughout the Uniform Commercial Code, most of which are designed to adapt the other chapters of the Ohio Revised Code that comprise the UCC in Ohio to deal with digital assets. So you have my written testimony, which goes into a little bit more detail, but unless there are questions about the specific provisions of the Act, I think that's probably sufficient for my verbal testimony.
Great. Mr. Ferriel, thank you for your testimony. Are there any questions for the witness? Representative Wolfslager with question.
Professor Ferriel has been here many, many times on UCC issues and has always been very informed and very helpful to whatever chamber I happen to be sitting in. I first got to know him as a student at Capital Law School, and lucky for him anyway, he didn't have to put up with me in class. I don't know how that worked, but it worked out that he didn't have to stare at me.
I always remember when House Judiciary Chairman Danny Bupp introduced me as his torts professor, which was of course completely wrong.
Representative Williams with question.
Thank you, Chairman. Thank you for coming to testify today. So, I mean, my only concern, my first concern when we get into the UCC is language that, directs us to respect the laws of another state. And I brought that up during the sponsor's testimony. And I do have a response, I believe you drafted for me.
Yep.
And it still raises a little bit of concern for me. I mean, in the response that you gave me, you wrote, the short answer is that the drafters believe that based on the history of the District of Columbia's enactment of uniform laws, that the district would be highly likely to adopt Article 12. So does that mean the district has not adopted Article 12 currently?
In fact, it has adopted it. It adopted it last year and it went into effect in April of 24. So Representative Williams' question deals with the choice of law provisions in the statute. In any uniform act that's going to be perhaps adopted in all 50 states, you need to have a rule for which state's version governs. And that's particularly important in any statute dealing with the rights of secured creditors, because lenders need to know which state's laws are going to govern perfection and priority of their security interests. The choice of law provision in this act has what we call a waterfall set of rules, a cascading set of rules that start with 4 provisions that apply the law of the state specified in the digital electronic record or in the system in which the electronic record is recorded. If for some reason there's a digital electronic record or a system for recording, keeping track of digital electronic records that doesn't specify a home state or a choice of law state, the default is to apply the law of the District of Columbia. Now there's a temptation to want to say, well, why not make it Ohio law? The problem, of course, would be Ohio might make the default Ohio law, and Pennsylvania would make its default Pennsylvania law, and Hawaii would make its default Hawaii law, and no one would have any idea which state's law governs. If all 50 states adopt the uniform version and adopt the District of Columbia as the default choice of law provision, and like I said, the district has already adopted, the chief legal counsel for the District of Columbia is a uniform law commissioner, and our bills tend to have a lot of success in the district. Why, if the district is the default, why then people can be confident of what jurisdiction's law applies. Furthermore, current Ohio law in another provision already selects the District of Columbia as the default choice of law jurisdiction in another situation involving intangible assets. So the precedent is there, and it ensures that lenders will be confident about whose laws are going to govern their security interests.
Follow up? No. Vice Chair Swearingen with question.
Thank you, Chairman, and thank you for this bill. I think it's critically important. My favorite story from commercial transactions was the guy that paid his taxes with a T-shirt and made out the amount to the IRS.
The negotiable cow case.
it was valid paper.
It's a British case.
Yeah. Gave the IRS the shirt off his back. The question I have is, and Representative Isaacson kind of explained this in previous committee hearing, but what's the status now? I mean, what does this look like currently? Because I have to imagine it's just a hodgepodge of contracts and uncertainty.
Yeah, so currently the most important, so you're right, it's a hodgepodge of common law rules that govern transfer of digital electronic assets. And of course, there isn't a clear rule about which state's law governs these transactions, mostly governed by contracts. The most critical part of it, though, are the rules for secured lenders. These assets lose a great deal of their value if you can't use them as collateral for a loan. And lenders are reluctant to loan money when they don't know what the rules are going to be. Under current Article 9, digital electronic assets would be regarded as a general intangible, which means it doesn't fit anyplace else. It's not goods, it's not a promissory note, it's not a warehouse receipt, it's an intangible asset that's just kind of a general intangible. The current law is for a lender to perfect its security interest in a general intangible. The lender would need to file a financing statement, a UCC-1, with the state secretary of state in the jurisdiction where the debtor is located. If you're buying a digital electronic asset, you might be buying it from an anonymous seller. You don't know who the seller is. You don't know which state secretary of state's office to search in, and you might have to search title in a foreign country if the debtor is located in a foreign country that has a filing system similar to Article 9. This solves that problem and permits buyers and lenders to make a decision based on the electronic record itself without having to worry about whether there's a financing statement on file somewhere out there that we wouldn't know about. And if you don't know where there's a financing statement that might be on file, you got to search everywhere, which is highly impractical.
Follow-up?
At the risk of putting everyone else to sleep with a follow-up question, I think it is important. What about the existing digital assets? So what's the transition going to look like from the assets that exist now and then getting them online in this electronic system and somehow validating that title to those existing assets are free and clear? Is there some sort of process that?
So the questions I'm most anxious about deal with the transition rules. The transition rules are in what's going to be revised Code Chapter 1316. And they're incredibly intricate rules that provide for protecting creditors who currently have a perfected security interest in a general intangible to reperfect under the new rules within a short period of time after the new law goes into effect. So they're grandfathered in, their protection is grandfathered in, and they're given an opportunity to reperfect their security interest under the new rules. They work very much like the way the rules worked when the last big set of revisions of Article 9 were adopted in Ohio, gosh, I think in about 1990, wasn't it? So Mary Augsburger, the executive director of the Ohio State Bar Association, was my student at that time when she was legislative aide to Representative Senator Jacobson, and I worked with his office on those and similarly testified anxious about being asked about the transition rules.
Follow-up? Good. Representative Odioso with a question.
I think this is a very important bill. I totally get it. I share his concerns about the transition period and just want that noted for the record. This is obviously a quickly evolving area of the law.
Yes.
So enacting this, what happens when the rules change again? Could you spell that out for me and the committee? What is the process? And I may be forgetting this general process of UCC revision, but I'm anticipating that this particular area is going to be revised fairly quickly, unless you know of a different pacing pattern, but because it's such a new area of the law.
So let me try to answer your question. So the Uniform Law Commission spent 2.5 to 3 years developing this piece of legislation and finished its work in 2022. It's been adopted in, I think, 27 different states so far. So we've had a little bit of an opportunity to see how the transition has worked. And I don't believe there have been problems so far. The biggest concern is that there will be technological developments that the law will have to adapt to. This piece of legislation was very carefully crafted to be technology neutral. So it doesn't matter if it's Bitcoin or NFTs or any kind of technology that deals with blockchain or other types of digital assets. The rules have been designed to work effectively as technology changes. Now, does that mean there isn't going to be something we're going to have to deal with 4, 5, 8, 10, 15 years down the line? Of course not. Who knew when I took commercial paper in law school in 1976 that we were going to have digital types of property? So the main goal, and I think the main goal of the drafting committee, and I think generally the Uniform Law Commission, anytime it's dealing with technology, is to take a technologically neutral approach. So whatever we develop is adaptable to new technologies as they arise.
Great. Any other questions for the witness?
Thank you very much for the opportunity to testify.
Thank you. Next to provide proponent testimony is Andrew Nickel. Welcome to committee.
Thank you, Chair Thomas, Vice Chair Swearingen, Ranking Member Isaacson, and members of the committee. My name is Andy Nicol. I'm a partner at Benish Freelander. I specialize in finance. I represent banks and borrowers. I'm also the chair of the Ohio State Bar Committee's or Banking, Commercial, and Bankruptcy Law Committee. We've been tracking this law for a few years now, hearing periodic reports from Professor Ferriol, and we're wholeheartedly in support of this law. The importance of uniform laws in the kind of finance space are essential to making our system of finance work. And so unless there are any questions, I will stand by that support.
All right. Thank you. Are there any questions for the witness? Representative Sindberg, question.
Yes, thank you, Chair, and thank you for coming in today to testify. As you say, blockchain technology is very difficult to understand, and I'm still trying to wrap my head around it. As we move forward into the world of this type of technology and different financial assets and instruments, are you concerned that there's security opportunities for security to be breached, opportunities for nefarious uses of these technologies, or is it too late? Has the train already left the station?
Chair Thomas, committee member, am I concerned? Absolutely. I mean, there are real risks there. I don't think this is a regulatory bill. So this does not talk about the necessary securities features you might need with blockchain technology. It doesn't address those issues. So to your point, there's probably other areas of the law that need to address other issues with this kind of technology, but this does enable the banks and borrowers and purchasers of these assets to know when a purchase has happened and what protections they have following a purchase. And that was sorely needed in this area, but there are, there's legislation all over on this, so I'm sure there's more to come.
Follow up?
No follow-up. Thank you.
Vice Chair Swearingen with a question.
Thank you, Chairman. So if I understand this correctly, how this would work for digital assets is they would somehow be registered under this blockchain technology so that they're verified with their chain of title. And then you as a lender or representing a lender would feel comfortable taking those digital assets as collateral for some sort of loan. Is that the gist of what you're doing?
My high level understanding is the major protections here are the good faith purchaser protections that we have with negotiable instruments. And so when there is a purchase, a good faith purchase here, you take free and clear of other prior claims and interests. And so the security interest granted in these would qualify as a good faith purchase. And that would mean that we don't have to worry about the prior claims of prior people. So I don't know if every BitChain technology has a built-in register. I'm not technically savvy enough to know that, but I do know that it's the good faith protections that the lenders were looking for. And quite frankly, the value of the Bitcoin to non-lender purchasers. They don't have to worry that there is some hidden lien that they could never have discovered. And so everyone benefits by those good faith purchaser protections. And that's the main thrust here as I understand it.
Follow up?
The only concern, is there an issue for existing creditors on these assets and maybe bad faith debtors who then try to sell under our new framework and those previous creditors are, is there some sort of check there on that type of situation?
Yeah, so I mean, that probably goes to the transition areas of this law. It would be hard for outside of bankruptcy where you kind of have a freezing of the assets and then your filing a financing statement would entitle you to priority. Outside of that situation, where we currently stand is if the Bitcoin is sold tomorrow, you'll never be able to track it. And so you may, in theory, have a lien on it, but you would never lend value on that because you would never, it's like cash in your hand. Like you'll never be able to trace it. And so that's where the nice thing here is the perfection gives you both the opportunity to perfect by filing, but as we just said, that only really helps you in bankruptcy. It also gives you a mechanism to perfect by control. And that's where we anticipate the lenders will want to, much the way with deposit accounts where we have deposit account control agreements, we would have a mechanism to take control, which would give us certainty in our collateral.
Good. Any other questions for the witness? Seeing none, thank you for your testimony.
Thank you.
This concludes the second hearing for House Bill 195. Now I'd like to call up House Bill 260 for its second hearing. Here to provide proponent testimony is Richard Schuster. Welcome to committee.
Thank you. Chairman Thomas, Vice Chairman Swearingen, Ranking Member Isaacson, and members of the House Judiciary Committee. My name is Rick Schuster, and I am the Chief Legal Officer of the Supreme Court of Ohio. On behalf of Chief Justice Kennedy and the justices, thank you for allowing me today to provide proponent testimony on House Bill 260. This legislation is designed to repeal sections of the Ohio Revised Code that either overlap or conflict with the rules that have been adopted by the Supreme Court pursuant to its constitutional authority. These rules have been reviewed by the General Assembly on an annual basis and allowed to go into effect. This bill will allow the General Assembly to do a cleanup of the Ohio Revised Code. And I have submitted written testimony for you today, and I will spare you. I'm not going to reread it for you. But I do want to emphasize that the General Assembly is given the opportunity every year to look at amendments being proposed by the Supreme Court, and only those that you don't object to go into effect. And today what we're dealing with are statutes that either overlap or conflict with rules that you allowed to go into effect. And these rules were part of the proposed practice and procedure related amendments. And under the Constitution, once those rules go into effect, the old sections of the revised code that conflict or overlap are considered to be void. House Bill 260 is carrying out the intentions of the Constitution in cleaning up those older sections of the revised code that have been now superseded by the rules put forth by the Supreme Court, in which the General Assembly allowed to go into effect. The Supreme Court believes it is this body, the General Assembly and this committee, who have the authority to decide what should remain in the Ohio Revised Code and what should be included in House Bill 260. So we know that you're going to be looking carefully at this bill. We have provided in the written testimony a list of the sections of the revised code that we're looking to have eliminated and the corresponding rules of the Supreme Court that would require those eliminations. And we look forward to working with you in meetings to go over these in detail and answer questions and move to a consensus on what should be done. But ultimately, it's the decision of the General Assembly what to remove from the revised code. I do want to thank Representatives Odioso and Representative Matthews for sponsoring this legislation. And Chairman Thomas and members, I want to thank you again for allowing me to provide testimony. And now I stand ready to hopefully answer questions you may have about what is in the bill.
Sir, thank you for your testimony. Are there any questions for the witness? Representative Olsager with questions.
Yes.
No questions, just a comment. I've always been very extremely impressed with this gentleman's legal skill. 20 years ago, he and I spent about a year together working on something called asbestos tort reform. So good to see you again.
I think it was almost 2 years that we worked together.
It was very painful 2 years.
And it was a very enjoyable time. And the representative is a good advocate for many positions. And I think he will attest that I'm always willing to listen and compromise where that is important to get the best result for the citizens of Ohio. And we believe this bill is what's best for the citizens of Ohio because it promotes consistency and efficiency. Thank you.
Sure. Vice Chair Swearingen with question.
Thank you, Chairman. And I see the list of statutes that conflict with the rules. Was this your handiwork that you did?
No, I can't take credit for much of anything at this point, but one of my colleagues, one of the attorneys, I asked them to put it together so that you all could have it because I thought it would assist. When I read through the bill and looked at the corresponding sections, I personally found it very confusing, but I'll have to admit there are lots of things that I find confusing that other people don't. So I thought this might be a good aid to assist us as we discuss what you want to keep in the bill and what should be in the final bill as passed out.
Great.
I feel bad for that gentleman that he had to do that, but great work. Is there anything in the future to monitor future laws that may come before the General Assembly that conflict with Article 5, Section 5A1 of the Constitution?
Yeah, Mr. Chairman and members of the committee, yes, we can provide that to you. The Ohio Supreme Court can provide it to you. There will be numerous amendments coming forward for you to review this year. Some of them may have already come over here, but there is an extensive effort at the Supreme Court to review all of its rules and to make sure that any changes in them are done and submitted for consideration by the General Assembly. And I know that process has been going on. A number of those rules are now out for public comment, and then they will be coming to the General Assembly. But if this committee would we are happy to provide such a summary list with corresponding rules to help with your review of what is sent over.
Good. Representative Sindberg with question.
Yes, Mr. Chair, thank you for your testimony today. I believe there was, I'm trying to look for it and can't see it right now because there's so many changes and you may not be able to speak to this because again, there are so many, but there was something about the appointment of the grand jury foreperson that is now different, I believe, than it used to be. And that's something that's being changed in this.
It's not really different. There will still be a grand jury foreperson, and that is contained in the criminal rules of procedure. And in fact, it's mentioned in there several times. So under the old statute, which I think was passed before the Modern Courts Amendment, it talked about a foreperson being appointed. Under the rules of the court, it requires that a foreperson be appointed for a grand jury. It also talks about, I think, a deputy foreperson in there being appointed as well.
Follow up?
Nope, thank you.
Any other questions for the witness? Good. Seeing none, thank you for your
All
testimony.
right, thank you for the time today.
Our next witness is Mary Augsburger. Welcome to committee.
Good morning, Chair Thomas, Vice Chair Swearingen, and Ranking Member Isaacson, and the members of the committee. It's my pleasure today to be here to testify in support of House Bill 260 on behalf of Ohio's lawyers, law students, and judges across the state. We too support the bill because we believe this provides some necessary clarity and consistency between what's in the revised code and what's in the law. Ultimately, that will result in the saving of time as our lawyers are taking on client matters and trying to resolve them. And hopefully for the clients, that means saving some costs as well. So we think the bill will improve accessibility to resolving legal disputes, and that's why we support it. We too stand ready to comb through it with you and are happy to participate in any discussions and work through any necessary changes. So thank you.
Great, thank you. Are there any questions for the witness? Seeing none, thank you for your time. Thank you for testimony. This concludes the second hearing for House Bill 260. I'd now like to call up House Bill 132 for its third hearing. Our office received no in-person testimony for House Bill 132. Is there anything written? No written testimony. This concludes the third hearing for House Bill 132. Seeing no further business before the committee stands adjourned.